Makwaba eba POG Media. So na meshe sense your first time I visit POG Media. Meshe any day kwa so abejo post subscription. Now why hit the notification bell no na say POG de eba no Ghana authentic political updates are POG personal on sabit me aka na wo hu de call. Na meshe sense so pese o share comment about this media obetimi abo e the comment section or na me de na se so nko so be call subscribers are almost done it down okay home am I able anywhere a year update a year POG ranted and so yet about a highway so now yeah Jim Rapi yeah more a rise in manager say yeah call a year mammy a year to Kono a year John Dramani Mahama and so a Jinan Kofu could be a petitioner almost so at the bear to one the office so on share not just say on share a year Justice Tokonu and I say CJ Tokonu and so Muna just say on also a FM free and office as the CJ and my John Dramani Mahama and so te home committee and so it's me boy Juma and one that you are John Dramani Mahama as in sign Krata HSA a year CJ Tokonu on to me so and to one Juma so as the a year Chief Justice. Now we na a year Martin Pebu a year running maybe and so a day a year updates bi anaasɛ wɔaleki info bi kyerɛ sɛ ɛyɛ aside sɛ deɛ yɛtee ne nne sɛ ɛyɛ CJ Tokono nso abɔ asade Ecoas bi ma kyerɛ sɛ ɔsu sɛ ɔmo nso mbra na ɔmmɛboa no nam ɛkwan a ɛyɛ saa petition ɛno ɛyɛ a yɛwura John Dramani Mahama gyina so ɛde ayi na afiri hɔ no na nyɛ no nko ara nso wasa so abɔ ɛde ewura mpanyinfoɔ bi n'ase a na kyerɛ sɛ nsɛm a Martin Pebu akora ka no ɛdin bi te sɛ the former president of Ghana ɛyɛ John Kuffo0ur&OthersTo ɔno nso otumi kɔ ne nan ase ɛna ɔte kɔkɔɔ so no na ɛyɛ Otumfour ɔsɛe ɛyɛ the second so otumi bɔ wura na akakye akyɛ sɛ osu ɛde ɛyɛ ɔde nisuo ɛbɔ ɛde wura ɔmo akakye sɛ ɔmmɛboa no na kyerɛ sɛ wura John Dramani Mahama nso ntumi ɛnyɛ ho biribi ma no na kyerɛ sɛ sɛ ɔbɛsa aba abɛbɔ adwuma ɛde ama ɔman Ghana as
accountability of the judiciary taking the lead in making sure that we are resetting. This is a resetting agenda where we want to protect the public purse, not like somebody who came and by the time he was leaving,
Bear with them, let's try right now. And this is the argument that the former Chief Justice is going to the Ecoas court with. Now, but let's put it in context. What does all of this really mean, especially in the scheme of things as has been playing out at the Ecoas court over the period?
Well, Alfred, so if you recall, one of the actions that the now former Chief Justice took by way of a legal challenge to the processes that she was going through was the fact that she had gone to the Ecoas courts, in which she alleged violation of her human rights and also making other demands, including that of damages in the sum of $10 million. However, they had to deal with preliminary matters before even hearing the substantive case itself.
Yeah.
The preliminary matters, like I explained before, are in the nature of what we have in our local courts as injunction. So that if that preliminary hearing was granted, it meant that it would have the effect of, if it were in a local setting, putting the processes on hold.
Right.
However, hearing for that preliminary part of the whole suit was heard, but then the court had to adjourn indefinitely for a ruling on that particular matter. But Alfred, let's.
But has that ruling been delivered? No.
Not yet, because it was adjourned indefinitely for that ruling to be heard. That has not been done yet. However, because the substantive suit was pending, for which there was the expectation that the Attorney General of Ghana would enter or also file a defense to that particular suit. The argument which is being made now is the fact that the time allowed under the rules, which is 30 days, has elapsed. And that our Attorney General has yet not filed that process to defend the suit before the Ecoas court. And to that extent, she's asking the court, by virtue of this application, for a judgment in default of defense to proceed to rule in her favor. And the argument is simple. If the rules allow 30 days for you to file your defense, and that the 30 days have elapsed, you have not filed your defense, it means you do not have a defense to the suit. So proceed and give me judgment. That is the point where she's coming from. But as we progress, we'll hear what the Attorney General's office is saying, because our colleague Joseph Kofi spoke to the Deputy Attorney General, who has been explaining what their thinking is and what their understanding of the situation is. But let's look at the exact reliefs that the now removed Chief Justice is seeking from this particular court in respect of this matter. So one, she wants an order that the Ecoas courts, she wants an order that the courts grants her the relief in the original application. Now, mind you, the original one is the suit that I'm talking, the substantive matter itself. Because...
Including the $10 million
in
damages?
Yes. Okay. So it contains all that. And we'll go back to look at some of the things that were said in that particular one. That an order of this honorable court that the plaintiff applicant, now former Chief Justice, has made a case entitling her to the reliefs sought in the originating application. She goes on to say that an order of this honorable court, that's what she's asking, entering a default judgment in this suit in favor of the applicant, the plaintiff applicant, due to failure of the defendant respondent. Defendant respondent, here referring to the Republic of Ghana, represented by the Attorney General, to file a defense. And that for the fact that they failed to file a defense, a judgment, a default judgment should be entered in her favor. And then for such other orders that the court deems fit. Now, this is the basis for making that argument. I've already explained, but let's characterize them as they appear.
Right.
That the court rules require that responses be filed within 30 days. The argument is that between the time that the case was filed and now, that we still do not have a response from the Attorney General, is more than 30 days. And that to that extent, the Republic of Ghana having failed or neglected to file the defense within the timeline means that the Republic has abandoned the right to file a defense.
Right.
So this is what she's essentially put before the court, hoping that they will proceed to grant the reliefs that are being sought here by giving her a default judgment. So that's basically how things look like in this particular matter. Okay. But like I explained, the Deputy Attorney General has been responding to some of these matters, including what they are thinking.
Media message over like that's all subscribe to a POG political media so I need as well with me drop subscription. Now was sharing offer for so answer so at me account who the echo and the empire a woman Ghana the political space in now it's a matter they can do to say CJ Kofu say maybe a drew near or your home share to say on also intimi Samba back as the Chief Justice of Ghana. Me crowd says a crime be on also far so a dealing with issues no our day of my Ghana Bura mo UK as I the Bura a Ecoas and then be able to so Bura no so say Oba Ghana citizens in the Nancy so more not say on for pressure and found to you John Dramani Mahama so not say petition no cry no about a majority of Ghanaians no support say on so and so and word my name one fasa coin so and Kwan for so Ecoas for ni UK for ni na nkusi aga chese ono so ekofie ano akakot ejina home sebi akojina home na abusua meze beto aso na 187
or their understanding of the situation is and how even this suit got to their attention. So let's listen to Dr. Justice Remsai when he spoke to our colleague Joseph Akable on this particular matter.
We woke up to another process which was served on us from the court that the former Chief Justice is seeking judgment in default of defense. In other words, that we've not defended the substantive suit. We had 30 days to do so, and that we have not filed our defense. But our preliminary thought is that if we are objecting to the jurisdiction of the court, and the court has taken argument and has adjourned to give a ruling one way or the other, we do not exactly think that we have to file on the substantive issue, because the question before the court is whether the court has jurisdiction. The court has to clear that aspect first, and when it says that it has jurisdiction to assume, then they will order us to file our defense. And indeed, if the court was interested in getting the court could have ordered that we should file our defense together with our preliminary objection, because we were heard. It's not as if we argued that matter in court, in the Ecoas court, and we were heard. And the court in adjourning didn't give any further direction. They told us that they are rising, and then they have adjourned the case, indefinitely. And when they come back, they will give us further directions. So we were waiting for the court to give us further direction, only to be served with a notice for default of defense. So that is where we are at the moment.
So what are the next steps? You'll be applying for that to be thrown out as well?
Yeah, we would have to file to oppose the application for default judgment.
Well, so that's what the Deputy Attorney General, Dr. Justice Adam Semsa, is saying. They're going to file to oppose this default judgment that she's asking for.
Yes.
That's going to be the next step.
Yes, so what that essentially means is that they still are not going to file any process to oppose the substantive suit. And his explanation is that as at the time they were filing the process to challenge what we describe as preliminary hearing, one of the issues that they raised was the fact that the court did not even have the jurisdiction to hear the substantive matter. So they are saying that because they are waiting on the court to make a determination on that preliminary hearing, which includes their objection to the jurisdiction of the court, they did not think that, or they do not think that they have to file a defense to a substantive suit, which they have been challenging the jurisdiction of the court.
So they wanted that challenge of the jurisdiction to be cleared,
determined
before
yes.
they would even respond.
So their understanding is that it is only when the court is giving its ruling on the preliminary hearing, and if the court says that it has jurisdiction to hear the substantive matter, it's only then that the court will order them to file a defense. So what they intend to do moving forward is not to defend the substantive matter, but to oppose this new move by the now removed Chief Justice to have a default judgment. So more or less like opposing the move to get the default judgment granted. So that's how things look like in this particular scheme.
No, but let's stay a bit on the reliefs, the original reliefs in the original suit that was filed.
Yes.
And not this one that she's just done this morning. The original. Let's just recall
subsequent to that, this was what they had for the preliminary stage. And if this were granted, that would mean that the thing was going to be on hold. And it's simply, as you see it, that the suspension of or the disciplinary or removal process against the Chief Justice pending the hearing and determination of the case, continuous enjoyment of paraphernalia and entitlements of the Chief Justice's office pending the hearing and determination of the case. These were the things that she was asking for, that she should be allowed. You know, at this point, she was suspended. So the argument was that she should be allowed to continue to enjoy the benefits that come with her office, pending the hearing and determination of the matter, and that's the substantive matter. And also that refrain from taking any other measures that may harm the rights claimed by the Chief Justice. So those basically were her reasons for making that move and asking that the initial stages, the preliminary matter, be determined. However, in opposing that, the Attorney General then simply made the case that as at the time that this application was made, it was made as though she was removed as a Chief Justice. But the Attorney General said no, she was still the Chief Justice, and that at the time of the application, she was the Chief Justice.
Even though there was an acting Chief Justice.
Yes, but she was the Chief Justice of Ghana. Because
at the time, that decision of her removal had not been taken as yet.
Exactly. And also because she alleged violation of human rights, the Attorney General also says that she has no personal right to the continuous performance of the functions of the office of the Chief Justice, where she is a subject of constitutional prescribed removal proceedings. This again responds to her pleading that she be allowed to enjoy the benefits that associate or that are attached to her office. The C talks about the fact that the suspension of the Chief Justice then from office of the Chief Justice was not done unilaterally, because there were allegations that it was done unilaterally and arbitrarily by the President.
Yes.
And that also that the suspension from office was done in accordance with the Constitution of Ghana. They cite Article 146 and all that. What is instructive in here is the G, where the Attorney General had made the point that the court is manifestly incompetent to assume jurisdiction over the substantive matter. So this is the point that Dr. Justice Srimsai is saying, that if they make a determination or the ruling comes and this matter is resolved, then the court will order them to enter a defense. In the absence of that, they are only minded to go and defend the new move which has been taken by the former Chief Justice. So that's how things look like as it stands, Alfred.
It's a development that we're following quite closely. And this is not the only one. Martin Bibu is going to be joining us in a bit. He's a private legal practitioner. But also, yesterday, Joseph Akable spoke to a former Chief Justice of the Republic of Ghana, who is now a member of the Council of State of this administration led by His Excellency the President, John Dramani Mahama. I'm talking about Madame Sophia Kofu. And she expressly stated clearly that she is not in favor of this decision that has been taken, and it appears to have corroborated some reports previously. He took issue with how her position on the matter was communicated earlier than yesterday before that exclusive interview with her, and the fact that in her view, the gravamen of the misconduct or the stated misbehavior on which basis this decision has been taken to remove the Chief Justice, in her view, is not weighty enough for such a punishment for that matter. This is what she had to say. Let's hear her, and we'll put some matters in context as well. Then it's going to be running through some other issues that have come on the back of this exclusive interview Joseph Akable had with Sophia Kofu. But this is what she said. Take a look.
the end, you look at the gravity of the harm that was done, if any. If any. That's all I've got to say on that.
And so as far as you are concerned, that also does not meet the threshold in your definition?
No, doesn't.
Do you think, and this is just a general question, do you think from what you've heard about the allegations, it should have crossed the threshold? I mean, I've seen suggestions that you abstain from the vote at the Council of State's level.
I cannot reveal what happened at the Council of State
But then the
level.
question is, do you think it crosses the threshold of a prima facie determination?
You think you can get me to?
Oh, no, my lady, it's a separate question. It's a separate question.
You think you're
because
separating it.
you have expressed an opinion on the 3 allegations that we've discussed.
Yes, and so deduce.
So as far as you are concerned,
from what I've said.
Is it a fair deduction to say that your opinion is that it does not cross the threshold?
It does not cross the threshold. The part I played in this matter was only in terms of prima facie. And prima facie only had to do with the facts as they are before you, or the allegations, and any supporting material as has been presented to you. Isn't that it? So, like I said, I didn't see what is in what came before them beyond what I had earlier on seen. And what I had earlier on seen was insufficient. Yes. It didn't even cross into the inquiry stage.
So a committee, in your opinion, should not have been set up to inquire into it?
I think it follows, doesn't it? It follows.
Well, so that's the former Chief Justice of the Republic of Ghana, also a member of the Council of State, indicating a number of things, including the fact that where she was involved in this particular issue regarding the...
That's it. So like you made you say POG or come on here about area you made you say POG about Ghana authentic political updates POG Media to pay and on phone submit me account the Ecoas and then the eba and say POG authentic political updates pen on submit me account on subscribe and make sure you drop subscription or wait me so I share or comment section or the POG Media brands here about the kind ama you made and so I'm me about your crabbe. Where is it? Ibesa Asia the next Jumeti Naya Sabiti, the Ecoas over my Ghana.